Does it matter who files for divorce first in California? Well, it depends. If you both are living in California and the divorce is uncontested, the other spouse is agreeing with everything, you both, one spouse files and the other spouse cooperates, you file the judgment paperwork, it doesn't matter. The only time it matters is if the other spouse, respondent, is living outside of California. For example, if you file for divorce and the other spouse signs a marital settlement agreement, that other spouse needs to notarize her or his signature. So it's better if it's uncontested that the spouse who is living outside of California files for divorce so that the California spouse can notarize the marital settlement agreement. And then, of course, if you're going to trial, then as a petitioner, you get to present your case first. I hope that was helpful. Bye. Should I stay or should I go? A lot of divorcing couples are asking when seeking legal advice when they're considering custody and visitation schedule. Well, warning number one, whoever is leaving, establishing a schedule with the children that's going to last for a very long time. For example, if father leaves and mother stays at home with two children and he comes and goes maybe once a month, that might stay for a long time and it will end up in court, and the step-up schedule is going to be very gradually painful, and therefore before leaving, consider staying unless you don't mind having that schedule or if you move next door. I hope that was helpful. See you later. Bye. Have you ever wondered what deposition means in family law? Deposition is a discovery tool. So, for example, you have a case where the other side is alleging that prenuptial agreement is not valid, and you filed for divorce, but you don't know why they think it's not valid. So, at the deposition, you invite them to, for example, your office. There, you have to pay for a court reporter, and then for the transcript, prepare and ask questions. Why do you think the prenup is not valid? And then along the line, for example, six months later to a year, there is a trial and they use different arguments. The other side is using different arguments why prenup is not valid. And you can impeach, meaning challenge their credibility and say, look, but that's not what you said at deposition. So it's a really good tool to use. I hope that was helpful. Bye. Motion in limine is a tool that I can use before trial. If I file a motion to eliminate or in limine, it means I ask the court to strike and not allow to introduce a topic. For example, I can ask that the court orders the other side is not allowed to introduce any evidence related to anything that was said during the mediation because it's confidential. Also, I had a case where a judge on his own said that the other side is not allowed to speak about immigration because it might affect their immigration status. So when spouses are fighting in court, they might say things that can be used against one of them in immigration court. I hope that was helpful. 6 months and 1 day of cooling off period means that the court cannot declare either party single after filing a divorce. So, for example, petitioner files a divorce, serves the other side, and then the divorce is going on for 2 years. The court is not allowed to declare in between day 1 and day 6 months anyone single. So there are two options. Number one is to file for bifurcation status only after the 6 months and 1 day cooling off period, or wait until the divorce is completely final. So if you do file a bifurcation status only, then all other rights for pension, everything else needs to be reserved for later. So this topic is going to be bifurcated, separated. So it's not happening automatic. Why divorces are so expensive? Aside from an obvious fact that lawyers are expensive, two things happen. Number one, divorce is a very emotional period of time for anyone. And I always suggest to any client who is going through a divorce to hire a therapist who is highly equipped to deal with emotionality. A lawyer is not a good person to call when someone needs to vent. And then the second point is the other side. If the other side is using this process to get back to the spouse and is using a lawyer who is over-litigating, that's adding up to the cost. So the least expensive process is uncontested, when both parties are in agreement and when both parties are reasonable. And I always suggest to mediate, especially when children are involved, because it does affect them significantly. A lot of times potential clients call and ask for advice about how to get sole legal physical custody and not have visitation with another parent. And I always say the same thing. Let's lay foundation. The court looks at what's best for the child, and it's usually continuous and constant contact to both parents. So it's not enough that he's not feeding the right food or doesn't do the homework the same style, parenting style the other parent does. But what does matter is domestic violence abuse or any type of abuse that affects a child and child's well-being. And so also a lot of times I warn the clients to be very careful about alleging abuse when there is none. For example, fighting in another room and being passionate about it is not enough. In California, it is possible to get divorced without other side participating. If the other side doesn't want to get divorced, you can still get divorced through a default. If you don't know what it is, contact your lawyer before filing for divorce. Mediation is a process where a mediator is not representing you or your spouse. Mediator is a neutral facilitator who is helping to resolve all issues in divorce. Ideally, a mediator is someone who is a certified family law specialist who can help draft all the paperwork necessary. When you go through mediation, a mediator will also advise each of you to seek an independent counsel right before an agreement is to be signed or in the middle of mediation, because the mediator is not allowed to give you legal advice and tell you what to do. A mediator will say, well, I think this is what will happen in court if I were a judge, or this is what happens in my experience. And so mediation is the least expensive process, and you can still have a lawyer and go through mediation. That's the ideal uncontested case. I had a client who had twins, and she thought she can get her custody back that she already lost. And so when I took over the case, we started working together. She calls me up and she says, my ex, after visitation, threw bleach in my face. I was like, what? So she called police, she called fire department. They started to investigate. They went to her ex, interviewed her, and her ex said, I didn't do anything. And so the police officer decided to look around and found out that there is a camera across the street. And by looking at the camera, they found out that there was no ex around, and my client actually did it to herself and accused her ex to get more advantage in custody and visitation matters and tried to get kids back. So it didn't work well for her. She lost her credibility with this court for good, so she had to move to another state. People always ask me how much is my divorce is going to cost, and without knowing how complicated it's going to be, my straight answer is on average $25,000. And then when is it less than 5? Or when is it more than 25? So when people go to trial, that's when it can be easily more than 25 for attorney's fees, expert fees, potential deposition cost, and preparation for deposition. Deposition can be up to 7 hours, preparation potentially 10 hours, and preparation for trial 10 hours. The trial itself could be 1 day, which is 8 hours, could be 6 days. So you can do the math. If a lawyer is charging $300, $500, whatever each lawyer would charge depending on their experience. And under 5 is when you are in agreement with almost everything. A client comes to my office and says, my husband lives in Florida and I live in California and I would like to get divorced in California. So far, so good. So, one problem. If my client is living in California and he's living in Florida, by serving him in Florida, court is not going to be able to have personal jurisdiction over him, which means the court cannot make decisions about him and his case unless he has minimum contact to California. Minimum contact could be defined as doing business, traveling. At one point, we had to serve the other side who lived in Philippines while he was traveling in San Francisco, and we served at 3 a.m. at the hotel in order to get jurisdiction in California. This case was insane, but minimum contact is important for jurisdiction out of state spouses. Can children testify in California in their own custody and visitation matters? For example, like in Angelina Jolie case where the judge, although the children were over 14 years of age in California, they technically could testify. The judge denied the request to involve children in custody proceeding. So as you can tell, the court has discretion to validate the request or deny the request, whether or not children should be involved in the proceeding. In San Francisco specifically, it's called Tier 2 evaluation, where the judge could ask that a mediator, facilitator from the court will talk to the children and then report to the judge about the results of this conversation, and the judge can make a ruling based on the information the evaluator provides. Interesting comment about affair should be considered when dividing assets. And I think one of my theory that why fault state has been abolished is because, for example, let's say a wealthy husband who cheated had a wife on the other side trying to prove that he cheated, and while she's trying to prove, he can withhold these assets for a long time, and it's not benefiting anyone. So right now it's pretty simple. Everything is divided 50-50 from the date of marriage until the date of separation. And so adding a layer of affair and adding a layer of litigation is actually delaying the process of getting divorce done. So I think I agree that it shouldn't matter in family court system. It's nasty. To answer your comment about the people who are divorcing have to live separately in order to maybe define date of separation, the answer is no. After this issue has been heavily litigated, now effective on January 1st, 2020, Family Code Section 7070 states that the date of separation is a final break of a marital relationship, and two of the following has to occur. Number one spouse has expressed to the other spouse the intent to end the marriage, and number two, the conduct of the spouse who expressed the intent is consistent with the intent, meaning living separately but not going on vacations together, not pretending you're husband and wife, not having a sexual relationship, for example, or going to events and pretend you're husband and wife. Otherwise, if you live separately and act like it. How do I know if a client is a good client or not a good client? Well, the first question I ask is if I'm the first lawyer or not. When I am the fourth lawyer, I decline politely.